Welcome to the Afterspin, opinions from thought leaders in our state. John Hood and Chris Fitzsimon. Part of the repeal of the discriminatory HB2 legislation was a law that prohibited local communities from passing their own non-discrimination ordinances to protect LGBTQ residents. Now that law has expired and advocates are urging local governments to pass anti-discrimination laws. What do you think of this? Should HB 142 be reinstated? Do we need each community to pass laws, or should the state have responsibility? John?
Well, there is a conflict of principle here to some extent, just setting aside the specifics of LGBT as a protected class. There's always a kind of a tension between letting local communities go their own way, which is often a good idea, and avoiding a patchwork quilt of different regulations that companies, for example, that have to operate across the whole state or across many states, having lots and lots of different jurisdictions, imposing different kinds of rules on them, and instead wanting more uniformity. So there's a conflict between uniformity and local autonomy. When you add to that the complexities of the LGBT issue, which some of that is more complicated, as we saw with the dispute about the bathrooms. I recognize that it is unlikely that any community will follow Charlotte's very bad lead of trying to essentially mandate unisex bathrooms on private property. That was what actually really set off the legislature to act, was the failure to even let companies do their own thing. Remember, the state law, HB2, as critical as you might want to be of it, it didn't require anything of private sector. They could have bathrooms that were open to whatever attendance the clients wanted. They could have bathrooms that were rigidly segregated by sex. They could have something in between. That was up to the private companies. This was really about the government. The Charlotte ordinance had actually gone after private entities, trying to force them to get rid of sex-specific bathrooms, not gender-specific bathrooms, but sex-specific bathrooms. I don't think communities are going to do that. But as far as banning discriminatory practices in hiring and so forth, we'll have to see.
So do we need to renew HB 142, Chris?
What we need to do is pass a state law that says you can't fire someone simply for being gay, or you can't deny housing to someone for being gay or lesbian or transgender. We have that in a lot of states have had that with no negative implications, with no horrible crises or anything else. And it's just astonishing that in 2020 in the United States of America, you can marry someone of the same sex. We have marriage equality. I hope that continues even with the new court. But you could literally get married on Saturday and show up at work on Friday and put your husband or wife's picture on your desk and be fired with no reason at all. So that's the answer. That's the solution. And if the state doesn't do it, I do expect some progressive cities in North Carolina to want to give these basic human rights protections to a significant part of their population.
Very quick question then. Do you think, the legislature was controlled by Republicans when they passed HB2. Do you think the legislature would pass a law like Chris is proposing, John?
I doubt that at the present time, but I do think that those kinds of practices, which are already declining anyway, I think they will either ultimately be that these categories will be added to anti-discrimination laws, or the practice will become so rare that it won't be necessary.
Chris, do you think they would?
I wish they would. I hope that John is correct. I'm not so sure if we're not living through a backlash of against equality, but I hope that is not the case.
All right. Well, thank you for watching the Afterspin. We'll have more video all during the week on ncspin.com.